This podcast is about different types of consideration and specifically past consideration. There are three types of consideration. There's executory consideration, which is a promise to act in the future. It is a promise to do, pay, or give something in the future. For example, A agrees to pay B in exchange for B doing something for A. You enter into the contract, A is going to pay in the future, B is going to do something in the future. This is valid consideration. Executed consideration is an act exchanged for a promise. This is also valid. Past consideration, however, is when an act precedes a promise. So first you act, then after you act, I promise to pay you. Now, this is not valid consideration because you did not act in reliance on my promise. So past consideration is no consideration. And the test is going to be, is the act, which is the consideration, and the promise, are those dependent on that act, part and parcel of the same transaction? So as a simple example, A promises to pay B if and when B produces A's dog. This is consideration because B is going to produce A's dog. This is executed consideration. But if B first produces the dog and A, being grateful, promises to pay B in consideration of B already having produced the dog, that is past consideration. B did not act in reliance on A's promise because A's promise came after B performed. And the rule is that if there is to be valid, enforceable contract, the promises or the promise and the act must have been exchanged in return for each other. And the saying is past consideration is no consideration. Why? Why is that the case? Well, if something is done first, then there is a promise relating to such act or performance. Then the two are not tied together by the notion of agreement. So there's a promise, if first there's an act and then there's a promise relating to it, there's no agreement there. We need the idea that the buyer's payment has bought the seller's performance or promise. If that's the case, if first there's the act, then there's the promise, then there's no mutuality, no causal link between the act of performance and the subsequent promise. So that any detriment suffered by the performer of the act was not suffered in return for anything or the promise of anything from the other party. Anything promised as a result of past performance of the act in question is simply promised gratuitously. We need to find new consideration for the promise of further performance. In Eastwood and Kenyon, Sarah's father had died when she was a child and her guardian had borrowed money in order to provide for her education and other needs. When Sarah grew up, she promised the plaintiff that she would pay the debt, the guardian. Now, Sarah married the defendant, and the defendant promised the plaintiff, the guardian, that the defendant would discharge the debt owed by the plaintiff. But Sarah's husband failed to make any payments and the plaintiff sued him. The issue is the discharge of a moral obligation sufficient consideration? Is past consideration sufficient consideration? Can a subsequent promise revive an earlier obligation? And the ratio is there is no consideration in past consideration or a moral obligation. Let's turn to moral obligation first. There would be no need for consideration if a mere promise created a moral obligation to perform it. In fact, and this is what the court was looking at, but this case is actually regarded as the final rejection of the idea that a moral obligation would support a promise. It used to be that the idea that the enforcement of promises is tied to a moral imperative of promise keeping, and cases, very old cases, used to talk about that. But this is the last case that talked about it. Instead of moral obligation, we rely entirely on the doctrine of consideration. So past consideration. The defendant's promise was not exchanged for the plaintiff's actions. Had Sarah requested the guardian to give her that money, the court might have inferred a promise to pay and therefore consideration. But, quote, consideration for the promise by the defendant was passed and executed long before. Now, how about a fresh promise? Because there was a new promise made after. Well, a fresh promise does not create an enforceable obligation. Quote, if the subsequent assent of the defendant could have amounted to ratification, the ratification should have been relied on as a matter of evidence. But this was obviously impossible because the defendant was in no way connected with the property or with the plaintiff when the money was extended. So this was a long time ago. The defendant came into the picture more recently. Now here, so they found no consideration. A modern court on the facts of this case would likely have been influenced by Sarah, the woman's estate, being unjustly enriched if she did not have to reimburse the plaintiff. This old claim would have been based in quasi-contract, which is an old action for money had and received. Now, this is now called restitution, but the claim was not pleaded in that case. So unjust enrichment or restitution was not pleaded here. It was only on the basis of the doctrine of consideration. In Lampley and Braithwaite, the defendant committed a murder and was going to be executed, and the defendant requested from the plaintiff to do what he could to obtain a pardon from him, a pardon for him from the king. The plaintiff did what he could, and he obtained a pardon for the defendant, and the defendant then promised to pay him £100, but the defendant later refused to honor his promise. And the court here had to look at an addition to this issue of past consideration. Is consideration past if it's coupled with a prior request? So here, the plaintiff was asked to do this, but there was no promise to also pay. The promise to pay came later, but what does that asking do? Well, a promise coupled with a prior request constitutes good consideration. And the reason for that is it is implicit with the request that there will be payment. A mere voluntary promise to pay after the act will not constitute consideration. But if that promise is coupled by a prior request, it will bind, because the promise is not a naked promise. It becomes a contract. Now, this is another case for the alternative argument of unjust enrichment. You could have argued unjust enrichment here because the defendant was unjustly enriched by the plaintiff's efforts. So the defendant gained something at the expense of the plaintiff. There's no juristic reason the defendant should have that, and so the court might find for unjust enrichment order restitution. But that was not pleaded here. Now, why Lampley and Braithwaite did not apply in Eastwood and Kenyon is because neither the services of the plaintiff nor his borrowing of the money had been requested by either the defendant in Eastwood and Kenyon or by his wife at the time of their provision. Later on, in a case called Powan, the Privy Council commented on what must happen for an act done before the giving of a promise to make payment or to confer some other benefit to be consideration for the promise to constitute consideration. First, the act must have been done at the promisor's request. Second, the parties must have understood that the act was to be remunerated either by payment or the conferment of some other benefit. And third, the payment or the conferment of another benefit must have been legally enforceable had it been promised in advance. And in Powan, Lord Scarman said that the subsequent promise to pay either, first, offers evidence that the party originally intended to compensate the other party, or it constitutes a separate positive bargain that would be enforceable. It doesn't matter which justification we choose, but the positive bargain does give us a better analysis here.